don't feel like I'm taking crazy pills anymore. The 11th Circuit has ruled against Donald Trump in the Mar-a-Lago classified documents case, and it is a beatdown. Now, because today is a day that ends in Y, that means this channel is here to explain what all of this means. Because try as I might to get away from Trump, he just keeps inserting himself into the most interesting legal cases in the country. So strap in for an explanation for why Judge Cannon might have ruled in Trump's favor initially. The Court of Appeals is not going to suffer any fools. So let's start with a recap of what brought us to this point. On September 5th, 2022, Judge Eileen Cannon, who was controversially confirmed to the bench after Trump was defeated for re-election, authorized the appointment of a special master to conduct an independent review of some 11,000 documents and some 1,800 items that were seized from Mar-a-Lago pursuant to a search warrant. Judge Cannon also took the extraordinary step of temporarily enjoining the government from reviewing and using the seized materials for investigative purposes, pending completion of the special master's review or further order of the court. In other words, Judge Cannon's ruling forced the DOJ to halt its criminal investigation of Donald Trump until the special master completed his work. Though she did allow the Office of the Director of National Intelligence, the ODNI, to continue its classification review and/or intelligence assessment of those documents. Now, the DOJ swiftly appealed Judge Cannon's ruling to the 11th Circuit, that is the Court of Appeals that oversees Judge Cannon. But it also separately petitioned Judge Cannon for a partial stay of her ruling. It went back to her to ask her to partially stay part of the things that she had ordered. Now, in that motion, the DOJ argued that Judge Cannon's injunction risked irreparable harm to national security by interfering with the government's criminal investigation and forcing disclosure of these classified documents to a special master. And the DOJ further argued that it's simply not possible to separate the DOJ and the FBI's criminal investigation, which was blocked, from the intelligence community's assessment, which was allowed to continue. As a result, the DOJ argued that the order had created confusion in the executive branch and disrupted intelligence agencies' ability to assess any damage to national security. For relief, the DOJ requested a partial stay of Judge Cannon's order that would allow the FBI to use the 103 documents marked as classified for further criminal investigation and not require the disclosure to the special master. And on September 15th, Judge Cannon rejected the DOJ's motion, and in her ruling, Judge Cannon refused to accept the government's argument that Trump could never assert any privilege or property interest on the documents with classified markings. Those are property of the government. Judge Cannon also refused to accept the government's contention that the documents marked as classified are actually classified or contain extremely sensitive information that could harm national security if disclosed. Judge Cannon then formally appointed Judge Raymond Dearie to lead an independent review of the seized materials. Then, after Trump and the DOJ submitted 2 names to be appointed as special master, Judge Cannon agreed to appoint Judge Raymond Dearie, who was one of Trump's picks, to lead an independent review of the seized material. She further directed Judge Dearie to prioritize review of the roughly 100 documents with classification markings, with a goal of completing the review of all the documents by November 30th, 2022. Now, we'll talk about this later, but Trump may live to regret this whole special master gambit, and especially regret agreeing to Dearie as the special master. But the DOJ then appealed the denial of the partial stay to the 11th Circuit Court of Appeals. So let's talk about this particular decision from the 11th Circuit. Now, legal experts attacked Judge Cannon's ruling en masse as legally unsound and ripe for being overturned. However, there was some concern that the 11th Circuit would let Judge Cannon's injunction stand. After all, the 11th Circuit is a relatively conservative court of appeals, with Trump having nominated 6 of the 11 active judges on the circuit. And recent history shows how some Trump appointees, like Judge Cannon herself, have been quite unpredictable in their particular rulings. But in a unanimous opinion issued on September 21st, the 11th Circuit Court of Appeals granted the government's motion for a partial stay. In a strongly worded 29-page decision, the 3-judge panel, made up of 2 Trump appointees and 1 Obama appointee, ruled that Judge Cannon likely erred as a matter of law by exercising jurisdiction to, quote, enjoin the United States' use of classified records in its criminal investigation and to require the United States to submit marked classified documents to a special master for review. Now, this decision was per curiam, meaning that all 3 judges equally supported the opinion. And as a result, the Justice Department was no longer prohibited from investigating the documents marked with classified markings that were seized, nor would it be required to share those materials to the special master for his independent review. But it's not just that the 11th Circuit granted the DOJ its requested relief. What's so notable about this opinion is how it reads like a complete repudiation, both the legal reasoning behind Judge Cannon's order and some of Trump's more specious factual claims. Now, in deciding whether to grant the stay pending appeal, the Court of Appeals evaluated 4 factors articulated by the Supreme Court in the Enken versus Holder case. First, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay, 3, whether issuance of the stay will substantially injure the other parties interested in the proceedings, and 4, whether the public interest lies. And on every single point, the 11th Circuit sided with the DOJ to find that the stay pending the appeal was justified. Now, for the first factor, the DOJ demonstrated that it was likely to succeed on the merits of its claim under the Ritchie analysis. Now, when a person seeks return of seized property in a pre-indictment cases, those actions are governed by equitable principles, whether viewed as based on Federal Rule of Criminal Procedure 41G or the general equitable jurisdiction of federal courts. That's according to the Ritchie case. And under the Ritchie case, when evaluating whether to intervene pre-indictment, courts assess 4 factors pursuant to Ritchie, which we talked about in our prior video. 1, whether the government displayed a callous disregard for constitutional rights in seizing the items at issue. 2, whether the plaintiff has an individual interest in and need for the material whose return he seeks. 3, whether the plaintiff would be irreparably injured by denial of the return of property. And 4, whether the plaintiff has an adequate remedy at law for the redress of his grievance. Now, under all 4 of the Ritchie factors, the Court of Appeal found that the DOJ was likely to succeed on the merits of its claim, namely that Judge Cannon's order blocking the criminal investigation and turning over classified records to the special master was an abuse of discretion that was made in error. Now, the panel noted that even Judge Cannon found no callous disregard for Trump's constitutional rights, and neither party contested this finding. And the Court of Appeals pointed out that this alone should have been enough to end the district court's inquiry. Quote, "The absence of this indispensable factor in the Ritchie analysis is reason enough to conclude that the district court abused its discretion in exercising equitable jurisdiction here." Now, it's basically judicial lawyer speak for telling Judge Cannon politely that her entire analysis was flawed from the very beginning. Now, this is a factor-based test, but basically the court can almost never exercise its equitable jurisdiction without the presence of callous disregard for constitutional rights. And in this case, it wasn't even close. But for the sake of doing a complete takedown of Judge Cannon's opinion, the Court of Appeals continued. Now, for example, while Judge Cannon was open to Trump having a potential property interest in classified materials, the 11th Circuit was skeptical that Trump had any property interest in them at all. Quote, "For our part, we cannot discern why plaintiff would have an individual interest in or need for any of the 100 documents with classified markings." Discussing the law of classification, the court explained that access to classified information is only allowed if a person has a need to know the information, or if the current administration has waived this requirement. But as the Court of Appeals noted, Trump hadn't provided any evidence that either of these things had happened. Quote, "Plaintiff has not even attempted to show that he has a need to know the information contained in the classified documents, nor has he established that the current administration has waived the requirement for these documents. And even if he had, that in and of itself would not explain why plaintiff has an individual interest in the classified documents." The Court of Appeals called Trump's suggestion that he declassify these documents a red herring because declassification would have zero effect on the character of the document and would not explain why he has a personal interest in them. As many legal experts have noted, Trump has repeatedly claimed on social media and in interviews that he declassified the documents, but Trump specifically avoided making these claims in a judicial setting supported by, what's the word? Evidence, that's it. No evidence whatsoever. And the Court of Appeals noticed, quote, "The record contains no evidence that any of these records were declassified, and before the special master, plaintiff resisted providing any evidence that he had declassified any of these documents." Now, what the Court of Appeals was referring to was just days earlier, Trump's lawyers specifically refused the special master's request to provide evidence that these documents were declassified, claiming that doing so would force Trump to, quote, "disclose a defense to the merits of any subsequent indictment." And in fact, they're absolutely right, and it would be entirely prejudicial to disclose a defense to an indictment, but those are post-indictment arguments, not pre-indictment arguments like what we're dealing with right here. But they should probably talk to their client about that because he keeps going on TV and locking himself into specific defenses that actually are not particularly good defenses at all. Go figure. But at any rate, regarding the third Ritchie factor of irreparable harm to Trump, Judge Cannon had argued that he could be potentially harmed if the classified documents were not returned based on 1, improper disclosure of sensitive information to the public, 2, the United States retention and use of privileged materials, and 3, the stigma associated with future prosecution. But the Court of Appeals explained in meticulous detail why all of those arguments were 100% wrong. For starters, the whole reason the government was investigating the documents was to limit unauthorized disclosure. And Trump has not asserted attorney-client privilege over the classified documents, so there can't be a harm to his privilege there either. And as to the final Ritchie factor, which asks whether the plaintiff has an adequate remedy at law for the redress of his grievance, well, the court noted that Trump has a remedy at law. He simply has chosen not to invoke it. The court explained that Trump could file a Rule 41G motion to get the documents back, but he hasn't. But even if he did, Trump, quote, has not identified any reason that he is entitled to those documents. So based on the four-factor Ritchie test, the DOJ demonstrated that it was likely to succeed on the merits. But returning to the NCAN analysis, the Court of Appeals held that the United States would suffer irreparable harm if Judge Cannon's injunction was not partially stayed. Finding that the government's national security review is inextricably intertwined with its criminal investigation, the 11th Circuit explained that allowing the order to stand would create a chilling effect on national security. Basically, it's not good for the government when it cannot control extremely classified documents. And to illustrate this, the court noted that officials who oversee both national security and criminal investigations into classified information might be forced to choose between doing their jobs and facing contempt charges. And with respect to the third NCAN factor, the DOJ demonstrated irreparable harm, while Trump had not demonstrated irreparable harm. The court reiterated that Trump does not have a possessory interest in the documents at issue, so he does not suffer a cognizable harm if the United States reviews the documents he neither owns nor has a personal interest in. Nor, the court affirmed, is being criminally investigated itself a substantial injury to justify a stay. Quote, bearing the discomfiture and cost of prosecution for crime, even by an innocent person, is one of the painful obligations of citizenship. That is, of course, according to the famous Supreme Court case of Kobldick versus United States. And finally, regarding the public interest factor, the court noted that the classified documents contain information that, quote, the unauthorized disclosure of, which reasonably could be expected to cause exceptionally grave damage to the national security, the public naturally has an interest in ensuring this does not happen. However, a national security assessment can only be done if the government is allowed to review these documents, which under the current injunction couldn't have happened. And having found the balance of equities overwhelmingly favored the DOJ, the Court of Appeals granted the motion for partial stay of Judge Cannon's order pending the entire appeal. Now, essentially, the Court of Appeals eviscerated Cannon's order regarding the classified documents and all of its underlying logic. But here, the DOJ's appeal was very narrow. Probably for strategic reasons, the DOJ only appealed the order regarding classified documents. That basically narrowed the focus of the Court of Appeals on the classified documents issue to ignore everything else. But the upshot, though, is that the rest of the special master order remains, which for reasons I'll explain in just a moment is kind of hilarious at this point. But let's talk about what happened next with Judge Cannon and the special master. Judge Cannon responded to the partial stay the following day by modifying her order appointing the special master. Judge Cannon revised her original order by excluding the 100-odd documents with classified markings from the special master's review, deleting the requirement that the special master submit interim reports and recommendations to the court throughout its review, and striking a provision requiring classified documents under review to be made available for Trump's counsel for inspection under the special master's supervision. And this might be the 11th Circuit's last word on this issue, and it may never get to the Supreme Court. Because according to many respected legal analysts like Steve Vladeck at the University of Texas, Trump can't ask the entire 11th Circuit to rehear the appeal en banc because the judge has basically removed anything that was objectionable. Same thing goes for the Supreme Court. And that same day, Special Master Raymond Dearie released a case management plan for his review of the Mar-a-Lago documents. Now, in this plan, he asked Trump's legal team to state by September 30th whether they believed any of the seized items were incorrectly described by the Justice Department's 11-page inventory list. And the judge also asked Trump's legal team to state whether they claim any of the items on the inventory list were not in fact taken from the premises. Trump has repeatedly claimed on social media and in interviews that the FBI planted evidence when they searched Mar-a-Lago, claims that his lawyers have specifically not made in court, probably because it requires evidence and subjects you to sanctions. Instead, Trump's legal team asserts that they can't affirm that the government's inventory is accurate without first reviewing the seized materials. But as to Trump's out-of-court claims of planted evidence, Judge Dearie is asking his legal team to, in legal speak, put up or shut up. And because Dearie is not putting up with some of the same nonsense that Cannon did, it seems like Trump may come to regret pushing for this particular special master. The impact of the 11th Circuit's ruling was immediate and not limited to Trump's case. The same day Judge Cannon modified her order, a Trump-appointed federal judge cited the 11th Circuit's ruling to deny MyPillow Lindell's motion for the return of his cell phone by the FBI. Mike Lindell, who you probably know, has propagated increasingly bizarre conspiracy theories about how the 2020 election was stolen and that he can get Donald Trump reinstated as president, is being investigated by federal authorities in connection with the breach of Colorado County's voting system. His phone was seized at a Hardee's drive-thru, which isn't legally relevant, it's just I think very, very funny. And bizarrely, hours after the Court of Appeals ruling, Trump went on Sean Hannity to vent about the variety of legal troubles that he's facing, like the New York Attorney General's civil fraud action against Trump and 3 of his adult middle-aged children. That was announced earlier in the day.
I actually thought that they would never bring a case And she brought it.
And when the conversation turned to the classified documents, Trump once again claimed he had declassified the documents. Trump claimed declassification procedures were essentially optional, telling Sean Hannity that as president, he had the power of declassification with his mind.
If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it.
And legal experts weighed in, and it should come as no surprise that no, the declassification processes are not optional, and presidents cannot declassify them with their mind. And in addition to producing a new psychic presidential power to Hannity's audience, Trump also speculated the FBI seized documents from Mar-a-Lago because they were looking for Hillary Clinton's deleted emails.
Were they looking for the Hillary Clinton emails that were deleted, but they are around someplace?
Yeah, I also don't know how that makes any sense whatsoever. But it's not hopeless for all those lawyers making terrible, terrible arguments and the former president. They can quickly get their brains back to functioning correctly with a logic or math course from today's sponsor, Brilliant. Brilliant is an online learning platform for STEM that replaces lecture videos with hands-on interactive lessons. Brilliant is for curious learners, both young and old, inexperienced and professionals, students, and those who are not studying anything anymore. You can quickly learn to ace your high school or college math course, or just learn stuff that you always wanted to learn. One of my favorite courses is all about logic, something we haven't seen a whole lot of coming out of Florida these days. But Brilliant's logic courses cover liar and truth-teller riddles, logical fallacies, machine logic, and even some strategic game theory. Logic is a crucial skill that lawyers need every day. Well, at least most lawyers. But Brilliant's statistics and finance classes are equally good. You will love them as well. Brilliant lets you learn by doing rather than just listening to hours of boring lectures. Learning through doing is scientifically proven to be the most effective way to master any new skill. The courses have storytelling, interactive challenges, and problems to solve. So you can sign up and start learning for free today by clicking on the link that's on screen right now. The first 200 people to sign up will get 20% off their annual subscription. So by clicking on the link that's on screen right now or in the description, you'll get 20% off your subscription to Brilliant. Plus, clicking that link really helps out this channel. And after that, click on this playlist over here for more Legal Eagle, or I'll see you in court.